Most everyone knows the saying, mother knows best, but is this always the case? When it comes to making medical decisions for incompetent patients with no prior documentation, should the ultimate decision be left up to the spouse or to the parents? If there's a living will or advance directive, physicians and family have no legal say in how the decision will be made, but in the case of Terri Schiavo, she was not so fortunate. The Terri Schiavo case was a legal struggle involving prolonged life support in the United States that lasted from 1990 to 2005. Before reviewing Terri Schiavo's case, it is well worth reviewing the legal background information that was ignored by Congress and the President. There's two cases, each of different young women who became incompetent in a persistent vegetative state that I will explain to you. In 1976, the case of Karen Quinlan made international headlines when her parents sought the assistance of a judge to discontinue the use of ventilator. Like I said, she was in a persistent vegetative state, so she had no say herself. The physicians had refused the request because they said they feared they might be held civilly or even criminally liable for her death. The New Jersey Supreme Court ruled that after a prognosis confirmed by an ethics committee that there is no reasonable or possibility of a patient returning to a cognitive sapient state, life-sustaining treatment can be removed and no one involved, including the physicians, can be held civilly or criminally responsible for the death. This ruling gave patients and families the right to live each stage of life, including the last stage, with dignity and respect. And for medical institutions such as hospitals, hospices, and nursing homes, that would now be required to establish and maintain ethics committees. In addition, the Quinlan case led to the creation of the living will, sometimes called an advance directive, which outlines the personal wishes of the individual in regard to extraordinary means to maintain life. Although the Quinlan case was widely followed, the New Jersey Supreme Court could only make decisions for New Jersey, not the whole country. When the U.S. Supreme Court decided the case of Nancy Cruzan, the other young lady I will tell you about, in 1990, it made constitutional law for the entire country. Cruzan was a young woman in a persistent vegetative state caused by an accident. Cruzan's family waged a legal battle to have her feeding tube removed. The case went all the way to the U.S. Supreme Court, which ruled that the Cruzans had not provided clear and convincing evidence that Nancy Cruzan did not wish to have her life artificially preserved. The Cruzans later presented such evidence to Missouri courts, which ruled in their favor in late 1990. The Cruzans stopped feeding Nancy in December of 1990, and she died later the same month. The Cruzan case energized a movement. It encouraged people to use the appropriate documents, such as a healthcare proxy or assignments of durable power of attorney, to designate someone to make decisions for them if they are unable to make them themselves. All states authorize this delegation and most explicitly grant decision-making authority to a close relative, almost always to the spouse first, if the patient did not make a designation before the accident. Sorry about this. Let me find my notes here. Also occurring in 1990 is the Teresa Schiavo, better known as Terri Schiavo. She collapsed in her home in full cardiac arrest. She suffered massive brain damage due to lack of oxygen, and after 2.5 months in a coma, her diagnosis was changed to vegetative state. For the next 2 years, doctors attempted speech and physical therapy and experimental therapy, hoping to return her to a state of awareness. Until her death in 2005, she had lived in a persistent vegetative state in a nursing home with constant care, being nourished and hydrated through a tube. Terri, before her catastrophic injury, did not put explicit treatment instructions in writing, just as the previous two women had not either. So according to the Nancy Cruzan case, Michael, her husband, became her decision-making authority or healthcare proxy. Michael, against Terri's parents, wanted the tube removed. He did not want her to live like that. In 1998, Michael petitioned the court to decide whether to discontinue the tube feeding. But unlike the Quinlan and Cruzan case, the Schiavo case involved a family dispute. Mrs. Schiavo's parents, the Schindlers, objected, but Mr. Schiavo wanted to detach the feeding tube that gave her nourishment. Terri would have never wanted to be kept alive that way, he said. but the Schindlers insisted that the tube be kept in place. They said is what their daughter would have wanted. To Mr. Shivo, the woman he had married was gone, but to the Schindlers, a sentient human was still in that body. There's an article it's called From Private Ordeal to National Fight, the case of Terry Shivo. It explains all the legal ordeals that Terry's husband Michael went through and the Schindlers, her parents, went through to try to, for Michael, take the tube out and for the parents to leave the tube in. Florida courts sympathized with the parents, but they consistently sided with the husband as a matter of law. But the Florida politicians got their noses into it, and in 2003, the state legislature passed a bill giving the governor, Jeb Bush, at the time, the authority to remove the feeding tube. But later, this was declared unconstitutional by Florida Supreme Court, and now they called it Terry's Law. That's a common legislative tactic, identifying a bill by some unfortunate's name to enhance its emotional appeal. As if the failed attempts at intervention by Florida politicians were not enough of a cautionary tale, Congress and President George W. Bush plunged into the fray. President Bush here, lost my spot again. President Bush in early 2005, he enacted legislation with dazzling speed to transfer jurisdiction of the case from state courts to federal judiciary. State courts did prevail, though, and the feeding tube was removed, and Miss Shivo died at the hospital in Pinellas Park, Florida, in 2005. This particular case brings up moral issues, and the moral issue is how government treats those who are in the dawn of life, the twilight of life, and the shadows of life. So the shadows of life being Terry, Nancy, and Karen. Medical ethics comes in the fact that life support, there's different kinds of life support. You can be artificially hydrated, and that's what Nancy was being. She was being fed through a tube. She had no quality of life. And also, she lost her autonomy to make her own decisions. She had no decision-making cognitive ability, and that was not respected on her half. We have the right to be free from bodily intrusion. No one can touch you or intervene you without your permission, but in her case, she had no permission to give because she had no legal documents giving her health care wants and needs if she was unable to make them. Upon reading this case study, I found myself pondering my own healthcare decisions and how I'd want them carried out. I'm only 26, but still it's something weird to think about. These women were young too, and then all of a sudden, one day, they're unable to make their own decisions, and then it falls upon the family, and then you don't want a huge argument in between your family. So, working in the healthcare field, I deal with patients and their rights on a daily basis. There's a moral code of ethics for nurses that includes autonomy, beneficence, non-maleficence, fidelity, and justice. And the principle of autonomy, as I said earlier, means that the patients need to make the decisions for themselves, but that didn't happen. And Michael Shivo said that his wife would not have wanted to go on in a persistent vegetative state, yet he waited a long time to make that claim. So what took so long to make that decision for her? He ignored his wife's wishes and violated her autonomy for many years. Terry Shivo's parents say that even if she had a living will, they would have ignored it. That doesn't make any sense, because that's what she wanted. Under cross-examination during her trial, her parents also say they would have amputated all 4 of her limbs and sought open heart surgery if they needed to keep her alive. This sentiment represents a clear violation of the principle of autonomy. There is no evidence that vegetative patients experience hunger, thirst, or physical, psychological, social, or spiritual pain. Suffering is a conscious experience, and vegetative patients lack consciousness. gathering information from this course, I can't help but to refer back to the utilitarian approach. Utilitarians believed in the principle of utility, the principle that requires us in all circumstances to produce the most happiness as we can. The utilitarian approach to Terry Schiavo's case is simply explaining away that medical treatments and therapy were no longer producing happiness, but instead prolonging misery and unhappiness. Terry's parents were devout Catholics, believed in the sanctity of life, but was Terry really living, or was she just existing? It's hard to conclude how this case should have been handled. I believe we do not know how we are going to act in a situation until it actually happens. We can make judgments and use research to show how one should act, but in all reality, we are human beings and we have feelings. Whether you're siding with Terry Schiavo's parents, who want their daughter to receive nourishment, or her husband, who says Terry would not want to be kept alive like that, difficult ethical issues underlie this tragic case. Many Americans are already debating them, have been debating them for years now. If there's no hope for an individual's recovery, should end-of-life care be continued? And who should make such decisions? I believe that this case was handled in an extravagant way. I would not want my family to go through court battles and such. I believe in the end, in my own opinion, that she was not really living and she was just existing as a body with no intellectual function. And it just is sad that it took so many years for people to side with the husband and realize, this is what needs to be done. But at being a parent, I can agree with the parents, as they don't want to get, see their child die. But there comes a point where, is that really still your child, or is it just the body that used to contain your child's soul? So, thanks for listening, and I appreciate it.